Okay, welcome again, everybody, to the inaugural Levine Lecture. We are delighted to have you join us for this very special occasion. I'm Camila Muscovitch, ICA's Executive Director, and the ICA is a trade association for the domain name industry, advocating on behalf of domain name registrants and owners. One area where we are very much involved is the UDRP and its reform. And last year, we awarded the Lifetime Achievement Award to Gerry Levine for his lifetime contributions, many of which are in the field of the UDRP. And today's lecture is a tribute to his contributions. And we are thrilled to have Tony Willoughby as our speaker. Thank you, Tony, for being here. We also look forward to the introductory remarks by Brian Beckham from WIPO and closing remarks by Gerald Levine. If there's time at the end of the lecture, we will take questions from Zach, Brian, and the audience. So if you have any questions, you can type them into the chat window. So without further ado, I would like to introduce Zach Muscovitch, ICA's General Counsel, who spearheads our work on the UDRP and so much more to continue with the program. Go ahead, Zach. Thank you.
Thank you. Thank you so much, Camila. So as you know, this is the Levine Lecture, and it's the inaugural Levine Lecture. The Levine Lecture actually had its origins in the throes of COVID in 2000. One day I got a call from Gerald Levine, who I was familiar with. We'd exchanged correspondence about UDRP and ACPA cases. I was, of course, familiar with this treaty's domain name arbitration, which is colloquially referred to as the Yellow Book, and had read his numerous Circle ID articles as well. And he said, you know, Zach, would you have any interest in getting together with a few other practitioners and panelists and experts to discuss UDRP over Zoom on a weekly basis? I said, well, sure, I'm in, but I'm not sure whether anybody else will show up. But a handful did, and a handful more than did. And 4 years later, what's become known as Gerry's Call has had 200 weekly meetings. Last year, the Internet Commerce Association said, how can we recognize the contribution that Gerry's made, both in his scholarship through his treaties and articles, and his work as a panelist, and his efforts at collegial interactions between stakeholders. And we decided that we would give him the Lifetime Achievement Award. Then ICA board member, Jay Chapman, had an even greater idea, and that's to have the Levine Lecture. And so here we are. The first thing we needed was a speaker of the kind of stature and authority befitting of Gerald Levine's scholarship. And that was, of course, Tony Willoughby, and we can't thank him enough for participating. And then we needed someone to introduce Tony. And Brian Beckham, who leads WIPO, graciously agreed to provide introductory remarks. Brian and I have worked closely in consulting on the UDRP and have become good friends, and can't thank him enough for graciously agreeing to introduce Tony. So I'll give it to you, Brian, for your introductory remarks of Tony. Thank you.
Well, thank you very much, Zach, and it's a privilege to be here. And I just have one small correction. I'm not quite running WIPO, but I am running its Internet Dispute Resolution team. So maybe that's a little bit down the road. But thank you very much. So just a few remarks. So I think a lot of you know that today we're approaching 25 years since WIPO created the UDRP. And in those years, we've heard that apps and then social media and so on will displace domain names. We have seen a number of treatises written on domain name case law, including the Yellow Book or maybe the Yellow Pages. I've received a copy of the blue version, which is quite a volume. We've seen ICANN introduce new GTLDs and new rights protection mechanisms, and we have seen a professional market emerge around the buying and selling of domain names. And as this lecture's namesake, Gerry Levine once suggested, it is concepts of fairness and predictability, traits which very much describe our speaker, Tony Willoughby. It is those such concepts which have provided the oxygen for the development of the secondary market for domain names. Turning to today's inaugural lecture, it is really a privilege to introduce Tony Willoughby to you today. As many of you will know, Tony is seen as one of the founding fathers of the UDRP and the case precedents that have developed over the past 25 years. It is indeed thanks to the investment of experts like Tony that the UDRP remains relevant today and is still seen as a fair and predictable means of resolving trademark and domain name disputes. No doubt, many of you will have read a few of Tony's decisions from over the years, and you will have seen for yourself that he is known for his fair and thoughtful decision-making. Indeed, in his very first case in September of 2000, Tony observed that, quote, on reading the papers, it seemed that the respondent was in possession of documentation, which if produced to the panel could assist his case. And in that case, he issued not one, but two procedural orders. Looking over some of the cases Tony has decided is a journey through time and covers already in the year 2000 cases involving Venus and Serena Williams and AOL, which is still around today remarkably. In 2006, Tony authored a novel case involving the English footballer Wayne Rooney. And then in 2008, there was a case for Velcro art, which sadly no longer resolves, as I would have loved to have seen the creative designs on that site. Tony was, among other things, the inaugural chairman of experts for Nominet upon its establishment of the UK's version of the UDRP, the DRS. Tony is a tour guide for and has written 10 books on Westminster Abbey. And for many years, we at WIPO had the privilege of he and David Bernstein sharing the stage to tirelessly and humorously provide instruction to UDRP case parties at our WIPO UDRP workshop. Above all, beyond being a reputed jurist, Tony is a kind and witty man. Now, let's hear from Tony.
Well, thank you very much. Good afternoon. I'm very conscious of the honor that you've done me, but I'm also very conscious that these lectures are a tribute to Gerry Levine, whose scholarship in the field of domain name disputes has won widespread acclaim, and deservedly so. His latest work, The Clash of Trademarks and Domain Names on the Internet, is a triumph. I've been asked to talk a bit about my background insofar as it's relevant to the subject of domain names, how I came to be involved in domain name disputes, my experience as a panelist both for Nominet and for WIPO, and my personal views on how the UDRP process might be improved based on my experience as a panelist. But I qualified as a lawyer in London in 1970 and joined the Trademarks department of the Distillers Company, the company heading a large group of companies engaged in the production and sale of potable spirits, mainly whiskies and gins, with Johnnie Walker, Gordon's and Tanqueray probably being the best-known brands today. The department also acted as the legal department for the Scotch Whisky Association, seeking to protect the geographical designation Scotch whisky. In 1973, I moved to join the patent department of Herbert Smith, a large commercial law firm in the City of London, where I was introduced to the full gamut of intellectual property litigation, and I remained there for 21 years. The law of passing off was my particular specialty. To succeed in a passing off action, one has to prove that members of the purchasing public are likely to mistake the defendant's product for that of the plaintiff, i.e., that the defendant's product is confusingly similar to that of the plaintiff. For that, one needs evidence. And at the Distillers Company, we were sent out into the marketplace to search for that evidence. We were lawyers, but the head of the department reckoned that we couldn't advise sensibly unless we had personal knowledge of the strength of the evidence. Solid evidence was crucial. At Herbert Smith, alongside my traditional IP litigation work, I developed an anti-counterfeiting practice. The law enforcement authorities were ill-resourced and had more important matters to deal with, so we had to find effective ways of attacking the counterfeiters in the civil courts. That work necessarily involved accusing the defendants of intentional wrongdoing, i.e. bad faith. But one never made allegations of that kind without strong supporting evidence. The English courts came down like a ton of bricks on lawyers making wild, unsupported allegations of bad faith. And it's with that background that I entered the world of domain name disputes. My introduction to domain names occurred in early 1997, by which time I'd left Herbert Smith and joined a very small boutique IP law firm in the East End of London. It took my name for the London end of the business, but reverted to Rouse, the name of its international consultancy business, when I retired. Pitman Publishing came to me with a problem over a domain name. Could I help? And this was in 1997. The only problem was that I had no idea what a domain name was. And it was an extraordinary story. In early 1996, they'd been allocated the domain name pitman.co.uk. Later that year, when attempting to connect their website to the domain name, they found to their horror that unbeknownst to them, the domain name had been reallocated to another Pitman business. It should have been impossible, but it happened. I wrote to Nominet inviting them to reallocate the domain name to my client, which they did. That provoked the other Pitman company to institute proceedings against both Nominet and my client for recovery of the domain. Happily, the court found in our favor, and my client held on to the name. It was the first domain name dispute to come before the English courts in open court. That experience prompted Nominet to introduce a dispute resolution policy, but it was not a success, and in 2001 was replaced by a version based on the UDRP, which by then was working reasonably well. But back in 1997, a couple of weeks after the Pitman case, I was visited by a Mr. and Mrs. Prince, whose IT consultancy had received a letter from Prince Sports Group Inc. of America, threatening them with trademark infringement proceedings for their use of their domain name prince.com. It was an extraordinary letter because Mr. and Mrs. Prince ran an IT consultancy, nothing close to sports equipment. Why had the letter been written? For one reason only. The network solutions policy covering the GTLDs required a complainant seeking to acquire a domain name registered by someone else to write to that someone else and threaten them with trademark infringement proceedings. If the addressee could not respond with a trademark registration, the domain name would be reallocated to the complainant, irrespective of the merits of the threatened proceedings. Mr. and Mrs. Prince, sadly, had no trademark registration covering their name, and it looked as though they would lose their domain name. However, the American company had made a mistake. In their letter, they referred to the UK trademarks as well as their US trademarks, and the UK Trademarks Act includes a provision entitling someone falsely threatened with proceedings to apply to a court for an injunction and a declaration of non-infringement. Had they not mentioned the UK trademarks, my clients would have lost their domain name. As it was, we were able to go off to court and obtain the requisite injunction and declaration, and the Princes held on to their domain name. That was the second domain name dispute to come before the English courts in open court. As you know, by the late 1990s, it had become plain that the problem encapsulated in the title of Gerry's latest work needed to be tackled, and in 1998, at the instance of the government of the United States, WIPO was instructed to investigate the matter and produce a report. The UDRP followed barely 18 months later. To have achieved all this in such a short space of time was quite remarkable, but it came at a price. The drafting of the UDRP is nothing like as tightly drafted as it might have been. It was intended to provide trademark owners with a swift, cost-effective method of dealing with a very specific, egregious form of trademark infringement known as cybersquatting, but neither trademark infringement nor cybersquatting is mentioned, still less defined, in the policy. And depending upon how one chooses to interpret paragraph 4B of the policy, it even covers activity which may not constitute trademark infringement. The looseness of the UDRP drafting, combined with the differing cultural, legal, and linguistic backgrounds of the panelists, and the absence of any system of precedent, meant that there was huge scope for differing interpretations. The ninth and final paragraph of the policy recognizes the likely need for variations to the policy, but the wording remains today precisely the same as it did on the day it was born, very nearly a quarter of a century ago. Credible dispute resolution systems rely for their survival on clarity, integrity, and consistency of decision-making. How is it possible that a system so vulnerable to inconsistency has survived, and indeed so successfully, despite all its faults? My only experience has been with WIPO, but I have absolutely no doubt that the WIPO overview lies at the heart of the policy's survival. It is a collection of the views of WIPO panelists taken from their decisions and identifying their varying approaches on a number of topics. The variations have narrowed significantly on the back of the annual panelist meetings and domain name workshops organized by WIPO in Geneva. The overview has been amended from time to time to reflect the growing consensus and is now in its third edition, but it too now is in need of updating. Nonetheless, it's proved a huge help to panelists, bringing together in a coherent form the issues most commonly faced by panelists. I'm aware that the overview has come in for criticism, and that panels are criticized for applying the overview instead of the policy in coming to their decisions. I venture to suggest that it is the looseness of the wording of the UDRP that deserves the criticism, not the overview. I was appointed a WIPO panelist in 2000, and issued my first decision, as you've heard from Brian, in September that year. There was very little guidance. Paragraph 10 of the rules sets out the general powers of the panel. Basically, we can conduct the process as we see fit within the terms of the policy and the rules. We have to treat the parties fairly. It's for us to determine the weight, admissibility, and relevance of the evidence. Paragraph 15 tells us that we have to decide the cases on the basis of the evidence before us, the policy and the rules, and any principles of law that we deem applicable. All in all, on the face of it, a very wide discretion, and all based on a less than perfectly drafted policy. A major issue for me with my background was the prospect of having to find people guilty of bad faith without having the benefits of discovery and cross-examination of witnesses. As I've explained, in my anti-counterfeiting practice, I was well experienced in accusing defendants of bad faith, but one only did so on solid evidence, on something approaching the criminal standard of proof beyond all reasonable doubt. The policy gives no guidance as to the standard of proof to be applied. The issue hit me very hard in one of my first cases, which, so far as I'm aware, is the only case of mine which was ultimately resolved in a court. The complainant was Reuters, the well-known news agency, and the domain name was ereuters.com, and it was connected to a website providing information and support for Asian maids. The respondent was a Mr. Tan, a Singaporean Chinese, who responded to the complainant's contentions, stating that until he received the complaint, he was unaware of the complainant and had registered the domain name for the purpose for which he was using it. But he didn't explain why he had chosen the name. The complainant contended that the website was a sham, but produced no evidence in support of the claim. It relied solely on the fame of the Reuters name. What was I to do? For all I knew, eReuters might have been a transliteration of the Chinese for the subject of the website. I felt unable to conclude that the respondent was a liar and deprive him of his online activity simply on the evidence before me. Should I issue a procedural order, quizzing the respondent as to why he picked that particular name? I thought about it, but I took the view that it was for the complainant to prove its case and not for the respondent to prove his defense, and I denied the complaint. That's when the fun started. A few days later, WIPO came back to me and said that the complainant had been in touch. The complainant wanted me to reopen the case, as they had now discovered that Mr. Tan had also registered Bloomberg.com. By then, I was functus officio. I could not reopen the case, so Reuters went off to court and obtained the desired result that way. If the issue arose again today, I'm pretty certain that I'd approach it in precisely the same way. But I'm also pretty certain that I wouldn't have to, because the complainant would have conducted the appropriate research into the respondent before launching the complaint. I now see from Gerry's latest masterpiece that I came in for some criticism for being too harsh on a complainant in making my first finding of reverse domain name hijacking back in 2000, partly on the basis that I dismissed out of hand the proposition that a renewal could constitute a re-registration, and partly on the basis that it was early days and parties, even represented parties, should be allowed a degree of tolerance. That first point, renewals, became quite a topic for debate, but at that time I was completely unaware of it. There was no system in place to inform panelists of the decisions of others, no overview, and it never occurred to me that a renewal could sensibly be regarded as anything other than a continuation of the expiring registration. As to the second point, with my background, wild allegations of bad faith in circumstances where the complaint had no chance of success had to be called out. It is appropriate here to pay tribute to Richard Lyon, a distinguished WIPO panelist who sadly died last year. He and I had strong views on panelists who denied complaints, but never appeared to consider reverse domain hijacking in their decisions. And we were also aware of a passage in the overview taken from several decisions which wrongly stated that for a finding of reverse domain hijacking, the respondent had to argue for it. That would have meant, of course, that in no response cases, there would never be any question of reverse domain name hijacking. WIPO invited us to present our views at one of the annual panelist meetings. Richard was a joy to work with and will be sorely missed. Other cases followed fast and furiously, one of which involved the Spanish Public Transport Authority with the acronym RENFE, R-E-N-F-E, which had accidentally allowed its renfe.com domain name to lapse. The Canadian drop catcher claimed never to have heard of the acronym. I had never have heard of it, and there was no reason in the evidence to suggest why he might have heard of it. I sent my draft decision to WIPO for formatting, denying the complaint, only to meet with the response, but what about your co-panelists? I had overlooked the fact that this was a 3-member panel. I duly apologized profusely to my 2 co-panelists and sent them my drafted decision for review. Shock horror. They both disagreed with me. One of them, who was also unaware of the complainant, accepted that the respondent might not have known, but both took the view that drop catchers should conduct searches on the previous owner of the name, and that not to have done so was an indication of bad faith. Whether or not there is or should be an obligation on registrants to conduct searches is another huge topic, involving, amongst other things, paragraph 2 of the policy, which points out that it's the registrant's responsibility to determine whether the domain name registration violates someone else's rights. I'm in the camp that regards paragraph 2 of the policy to be outside the scope of paragraph 4 proceedings. When it comes to bad faith, I do not accept that constructive bad faith is an appropriate test. For me, the evidence must support a finding of actual bad faith. On receiving a case, we have to file a declaration as to our independence and impartiality. In the 24 years that I've been doing these cases, I've had my impartiality challenged twice, and somewhat surprisingly, both challenges were made in the same case. The complainant was the energy giant Assia Brown Bovary, with trademark rights to the acronym ABB. They claimed that I was biased against them because I had previously found against them under the .biz stop policy in relation to the ABB.biz domain name. I had found in favor of the registrant who had got there first and also had rights to the same acronym. It was the Australian Barley Board. I declined to recuse myself and proceeded to work on the case in which we were involved, involving the domain name www.abb.com. The respondent kindly supported my refusal to recuse myself. However, it soon became plain that the respondent was not whom he claimed to be, and I issued a procedural order asking him to explain why his contact details were the same as those for the original registrant. He responded with a demand that I recuse myself, claiming that I was biased in favor of trademark owners and was insufficiently experienced to hold a position of panelist in these disputes, and that in one of the 100 or so decisions in which I've been involved, I had participated in a majority decision which the respondent's representative described as shocking. Needless to say, I declined to recuse myself and went on to order transfer of the domain name to the complainant. I should say that following that decision, the respondent made direct contact with me, confirmed that my decision was perfectly accurate, but all he was out to do was to cause trouble for WIPO. I don't know why. In April 2001, having issued 20 or so decisions, I wrote an article for Trademark World commenting upon the UDRP from the perspective of a UDRP panelist and drawing attention to, among other things, the looseness of the drafting of the policy and potential problem areas calling for clarification and hopefully amendment to the policy. I'm told that that article had some influence on those drafting the Nominet DRS, which was introduced later that year. One of the matters to which I drew attention was the requirement on the first element for the complainant to prove that the domain name was confusingly similar to the complainant's trademark. As a trademark lawyer, I knew perfectly well what it meant. Are internet users likely to believe that the domain name is in some way associated with the complainant? It made sense because to get a complaint off the ground, the complainant had to establish trademark rights, and the policy was restricted to trademark rights because, unlike other rights, trademark law is pretty uniform throughout the world, and confusingly similar is a concept common to most trademark laws. Blissfully unaware that there could be any doubt about it, my comment in the Trademark World article was simply that the word confusingly be dropped to make the panelist's task easier. After all, it's the second and third elements that are at the heart of the matter. Nominet adopted the suggestion for the DRS, but I was in for a surprise. In 2000, I had a case involving the domain name netscape.com, which I found not to be confusingly similar on the basis that no one in their right mind could conceivably take the view that it was a domain name of Netscape. When issuing that decision, I was completely unaware of a decision of David Bernstein's in the WalmartSucks.com case, in which he said that for him, the likelihood of any actual confusion was an irrelevance. For him, incorporating a distinctive mark in its entirety creates sufficient similarity between the mark and the domain name to render it confusingly similar. He went on to say the panel specifically rejects complainant's argument that consumers are likely to be confused as to the sponsorship or association of a domain name that combines a famous mark with a term casting opprobrium on the mark. For many years, these two views were reflected in the overview, indicating a lack of consensus. However, there was no dispute that the complainant's trademark had to be recognizable in the domain name, and that one simply compared the name and the mark. The website was irrelevant. That all came to a head about 10 years ago when a panelist adopting the orthodox approach dismissed a complaint on the basis that the French fashion brand Plein, P-L-E-I-N, was not recognizable in the domain name peopleincasinos.com. That seemed perfectly reasonable until one learned that the website to which the domain name was attached was offering for sale counterfeit Plein product. Unlike the policy, the overview moves with the changing times. It now states that the website may in certain circumstances be taken into account, and it also states that recognizability may include recognizability by technological means such as search engine algorithms. Thus, we are now in a situation where domain names such as fucknetscape.com and walmartsucks.com, which neither David nor I believe will be likely to lead to any consumer confusion, are nonetheless confusingly similar for the purposes of the first element of the policy. Somewhat illogically, that all changes for many of us when it comes to the second element of free speech. In relation to free speech, those same domain names cease to be confusingly similar. Subparagraph 4C3 of the policy provides that if a respondent can prove that he is making a legitimate, non-commercial or fair use of the domain name without intent for commercial gain to misleadingly divert consumers or to tarnish the trademark or service mark at issue, he can establish a right or legitimate interest in respect of the domain name. There is disagreement as to what that means. It raises questions such as, is it fair or legitimate to publish damaging material about the complainant using a domain name which falsely indicates that it is a domain name associated with the complainant? Some panelists, mainly those in the United States with an eye on the First Amendment, seem to say that it is fair. A large number of the rest of us accept that it may be legitimate to use a domain name identifying the complainant, but only if the domain name accurately telegraphs to visitors what the website is likely to contain, i.e. in the case of protest sites, domain names which are not confusingly similar, such as fucknetscape.com and walmartsucks.com. But we take the view that to use confusingly similar names for that purpose amounts to impersonation, and that impersonation cannot on any basis give rise to a right or legitimate interest under the policy, irrespective of whether or not a court deciding a case under national law might come to a different conclusion. The court will apply local law, whereas our law is the UDRP, a different law, a self-contained contractual dispute resolution process to be applied uniformly across the GTLDs and without regard to jurisdictional boundaries. My experience as a Nominet panelist informs to a significant degree my views on how the UDRP could be improved. So it might be helpful if I now edge away from the UDRP and take you briefly through the Nominet process, or at any rate those parts of it relevant to the discussion around the UDRP review. The Nominet DRS is based on the UDRP and reproduces in its text much of the wording of paragraph 4, although the second element features as a defense for the respondent to establish rather than a negative for the complainant to prove. The DRS procedure is very different. Nominet provides the service free of charge upfront. No fee is payable until the panelist is appointed, and all fees paid go to the panelists. The complaint is followed by a response, and the complainant then has the option of filing a reply. If there is a response, the parties are offered a free of charge mediation service by qualified mediators employed by Nominet. This process resolved a very significant number of cases. If there is no response, the complainant is offered the opportunity of paying for a much cheaper summary decision instead of a full decision. The sole difference being that in the case of summary decisions, the panelist is not required to write a fully reasoned decision. Whether or not there is a response, the losing party may appeal. When chairman of experts, I chaired all appeal panels. They were 3-member panels with the other 2 spots being taken by the next 2 first instance panelists in the rotation list. Our .UK procedure calls for a rotational system. Indeed, we have 2 rotational lists to cater for the 2 types of decision. The benefit of this type of system is that we all receive the same amount of cases of each type in any year, and there is no requirement for Nominet to get involved in the appointment of a panelist to a case. The appellate system was varied some years ago to iron out 1 or 2 problems, and an expert review group was formed, originally chaired by me, but now chaired by another WIPO panelist, Nick Gardner, who succeeded me as chairman of experts. This is a group of 5 very experienced former first instance panelists who now no longer hear first instance cases. The They hear appeals and review first instance draft decisions before they're published. The panelist has no obligation to adopt any suggestions made by the reviewer, and the reviewer is, of course, automatically disqualified from hearing any appeal. In about August 2001, a professor at the University of Ottawa published a detailed analysis of the performance of the UDRP after 18 months of its operation. He acknowledged plus points, but basically the piece was pretty critical. One of the complaints that he levelled at the system was the undisclosed way in which the service providers allocated cases to the panelists. He drew attention to some bizarre statistics as to the proportion of NAF cases handled by a minority of their panelists, and pointed out that it was a ready opportunity for the service provider to steer decisions in a particular direction. I don't know how far any service provider exercises that power for an improper purpose, but there can be a justification for it. In 2001, I received from WIPO 4 cases on the same day, all concerning .com domain names featuring the names of famous British novelists. It never occurred to me that there could have been anything untoward in the allocation of those cases to me. The complaints were all drafted in identical terms by the same lawyer representing each of the novelists, and they were filed at a time when there were conflicting views on whether a personal name was capable of constituting a common law trademark. It would have been an absurdly damaging blow to the UDRP if those decisions had been decided differently. However, it would not have been possible under the Nominet DRS with its rotational system of panel appointment. All 4 cases have gone to different people. I'm not sure that it would be possible for a dispute resolution service provider covering the GTLDs to operate a rotational system. In the UK, we have a relatively small number of panelists, all of whom went through an interview process in which I and subsequently Nick Gardner participated along with Nominet General Counsel. All were brought up in the common law tradition, although a few are not lawyers, and all have English as a first language. Our annual meetings are well attended, and at those meetings we discuss areas of potential disagreement, and so far as I'm aware, we have pretty well total consensus on the major principles. I don't know how WIPO allocates cases, but from the records to be found on the dndisputes.com website, one can see that the allocations vary considerably from one panelist to another. Language will be one factor. Another will be the nature of the country code TLD for whom they're the service provider. Complexity will be another. The scope for intelligent minds to diverge when construing the UDRP is huge, whereas with Nominet, the DRS policy is amended from time to time to iron out areas which need tidying up and is consistently construed. It is now in its 4th iteration. Consistency is everything. If any changes are to be made to the UDRP procedure, it certainly makes sense that the provider's methods of panel appointment are made public. Generally, on the question of amendment of the UDRP, I have over the years consistently advocated for major change. But having read some of the comments expressed by those considering review of the policy, it is clear that there's still a very wide range of views on a lot of topics. I'm not sure that a complete rewrite, desirable in an ideal world, makes sense. We're not in an ideal world, and I fear that unless the rewrite follows as far as possible the substance of the WIPO overview, we would in practice be likely to be left with something very different, destroying the heart of what has become an amazing alternative to litigation. Incidentally, I don't suppose that Gerry would relish the thought of rewriting the clash. The benefit has been primarily to trademark owners, as was intended at the very outset, but there's also been a benefit to those registrants who would otherwise have faced litigation. I have a Nominet story to illustrate the point. In the early days, there were a few rogue.co.uk decisions. One of them involved Hoffmann-La Roche's trademark Zenical. The domain name was zenical.co.uk. Suffice it to say that, surprisingly, the decision went in favour of the registrant, who had no obvious reason for registering the name. Within a matter of hours, literally, Hoffmann-La Roche went off to court and obtained an ex parte order for an injunction, and speedily came away with a judgment in its favour and a costs award of £6,000. Had the decision gone the way that the Nominet DRS anticipated, the respondent would have lost the domain name, but at no cost. Both the UDRP and the Nominet DRS ensure that both trademark owners and cyber squatters benefit financially. It enables both to avoid the horrendous cost of litigation. If a consensus roughly along the lines of the overview cannot be achieved, then I believe that the main body of the UDRP should be retained as is, but with an additional section clarifying those areas on which it should be possible to reach agreement. For example, the standard of proof to be applied. and that an additional example of bad faith registration in use is the provision of false contact information to the registrar. That would greatly simplify all the fraud cases, in none of which do the registrants provide true contact details. And then express provisions to the effect that trading in domain names for profit and holding a large portfolio of domain names are of themselves lawful activities, and that sale of traffic and failure to use a domain name are not of themselves objectionable under the policy. A provision favouring the complainant where the complainant paid for the registration and renewals and has made exclusive use of it would be helpful, as would one making it clear that the use of privacy and proxy services are not of themselves indications of bad faith registration and use. Most of those are express provisions in the Nominet DRS. Turning to more controversial topics, I'm conscious that over the years I've repeatedly argued for the removal of the conjunctive requirement of bad faith registration and bad faith use. The anomaly reflected in the terms of subparagraphs 4A3 and 4B4 was highlighted as far back as February 2000 in the early e-resolution decision in the Shermax case. Since then, apart from the Octogen debate in 2009-2010, the vast majority of us have treated 4B4 as a drafting aberration and interpreted in line with 4A3, which requires the conjunctive approach. If and suddenly becomes or, I fear for the flood of cases calling upon us to assess the quality of use of a domain name absent bad faith registration. Assessing bad faith use in the context of a bad faith registration is generally a relatively easy task, but absent the bad faith registration, it could be very much more difficult. Is it possible for a domain name to be registered in bad faith for a use in good faith? I came to the conclusion that it was in a case involving the domain name harrywinston.com, to which the famous Harry Winston jeweler took objection. The respondent was a pet shop owner in South Carolina with a hairy dog named Winston. She named her business after her dog and registered the domain name for her business website, intending that internet users would make the connection between the domain name and the trademark owner. As she put it, the name playfully suggests to the customer both high-quality goods and an incongruous association with the hairy canine world. In other words, a parody. She cited a few quotes from US court decisions, one of which is authoritative for the proposition that a parody must convey two simultaneous and contradictory messages, that it is the original, but also that it is not the original, and is instead a parody. I could have gone either way, but I decided that in registering the domain name with a view to profiting from the fame of the complainant's mark, she was not acting in bad faith. It was not unreasonable for her to believe that use of a parody was fair, and I observed that whether or not she was infringing the complainant's trademark rights, she could not sensibly be labelled a cybersquatter. I note that her website is still live. But now, what about a registration in bad faith for the purposes of a use in bad faith? Is it possible for such a registration to escape the inevitable order of transfer to the complainant? Well, apparently it is. I refer you to the 2012 case of the Australian brothel, which promoted its prostitution service online via the domain name victoriasecrets.com.au. The well-known lingerie brand wrote them a cease and desist letter in 2005, and the brothel replied denying the complainant's contentions. The complainant did not respond to that denial and left it 7 years before launching the complaint. The respondent was held to be entitled to assume that the complainant had accepted that its use of the domain name had at some stage in that 7-year period become a good faith use. The complaint failed. The result was, in effect, very similar to a finding of laches, I think you call it laches, a road that by and large most panelists have declined to follow. I had thought that this case would have been something of an outlier, but I see from the laches section in the Clash that there have been other cases decided along similar lines. Dictionary words. Can price alone be an indication of bad faith? I thought not. In my camper.net decision back in 2005, I rejected it as a possibility, and earlier this year I was a member of the 3-person panel in a case involving the domain name sage.ai, where we expressly stated that even where the respondent has knowledge of the trademark, that of itself is of no assistance to the complainant, absent something on top to show that the trademark is being targeted. More recently, another 3-member panel came to a different conclusion in the case of converse.co. They seem to have concluded that at the price he was offering it, only the complainant could have afforded it, therefore he was targeting the complainant. I see problems, but if that's to be accepted as the test, domain investors will need to be very careful how they price their portfolios. It would be good if the overview could cover the topic. Other differences between the Nominet DRS and the UDRP include the mediation process and appeals. I doubt that mediation will work under the UDRP. Who would pay for it? And I see huge difficulties in establishing an appellate system, a primary problem being to find an appropriate service provider. I don't think that it should be one providing the first instance service. And identifying a broadly acceptable group of appellate panelists who will not engage in first instance decisions could be difficult. If such a group of panelists can be recruited by an acceptable service provider, that would be wonderful and a very pleasant surprise, but I'm afraid I'm pessimistic. However, adopting a low-cost alternative along the lines of the Nominet summary decisions would be good, certainly in clear-cut, no-response phishing cases. I'm now coming to the end, but before I do so, I'd like to mention two cases that gave me particular enjoyment. And Brian's referred to one of them. The two Spanish ladies, artists working in very different genres, who had come together for a website combining their work, selected velcroart.net for that purpose. The complainant produced a substantial evidence to support the worldwide fame of the Velcro mark. The respondent said they were aware of Velcro as a generic name given to a type of hook and loop fastener, but unaware that it was a trademark. They selected the name as it was suitable to describe their coming together in their chosen art forms. In those days, panelists received the case papers in hard copy form. This case came to me in two large cardboard boxes, the largest component being photocopies of a vast number of dictionary definitions of Velcro. I read them all. In every one of them, Velcro appeared as a trademark, but in some of them, they were accompanied by examples of the usage of the term. Thus, one of them included an example from the New York Times reading, "Many colleges and universities have adopted a Velcro approach to curriculum design, sticking additional requirements on a base of distribution requirements." And then my favorite, from the American Heritage Dictionary of the English Language, included a quote from the Chicago Tribune reading, "In the early stages of a romance, the Velcro period, intimacy is rarely an issue." I accepted the lady's denial of all knowledge of the trademark and I denied the complaint. The other case, and perhaps the most extraordinary of all, involved the domain name newzealand.com, registered by an enterprising company in Seattle, which had registered a number of names of countries in the .com domain. The New Zealand Trade Board launched the complaint, contending that New Zealand is a trademark owned by citizens, institutions, and the state of New Zealand. It made this astonishing claim at the very same time that another member of the same trade board was arguing at WIPO that the UDRP should not be extended to country names. We were a three-member panel, and we're in no doubt that this was a flagrant case of reverse domain name hijacking. But I had reason to be nervous about declaring the complainant to be a reverse domain name hijacker, as my office was just down the road from the Tower of London, notorious for being the place where English monarchs dispatched traitors for execution. Why should that have bothered me? Well, the complaint named the complainant as Her Majesty the Queen in right of her government in New Zealand as trustee for the citizens, organisations and state of New Zealand. We found her a reverse domain name hijacker, but there was no comeback, and she didn't mention it when I had the privilege of meeting her a couple of years later. I'd now like to finish by expressing my gratitude to WIPO and to Nominet for having given me the opportunity to participate in the fascinating developing field of law. Both organisations have given me the opportunity of lecturing on domain names at home and abroad, and in the course of it all, I made some good friends, one of whom was Richard Lyon, whom I've already mentioned. Nick Gardner was a colleague with me at Herbert Smith, and he's taken over from me as Nominet Chairman of Experts. Andrew Lothian, another good friend whom I met through this industry, has taken over from me in co-presenting the WIPO workshops in Geneva with David Bernstein. When WIPO asked me many years ago to co-present the workshops with David, I was very nervous, conscious of his exceptional intellect, and there were several major issues on which we disagreed. Disagreements that we'd have to discuss in public. I risked public humiliation. However, I needn't have worried. He was very gentle with me, and we clicked from the start. It was a double act that I thoroughly enjoyed. He, like Gerry Levine, is another giant in the field, and I feel very privileged to have had the opportunity of working with him. We've become close personal friends. And thank you to ICA for having invited me to address you, and thank you to all of you for having listened to me. Thank you.
Tony, thank you so much for the lecture. Really, really appreciate you taking the time and speaking to us. And I will now turn it over to Gerry for his closing remarks. Thank you again, Tony.
So lest we forget, and Tony brought this up, but I think I want to underscore it. When ICANN implemented the UDRP 25 years ago, well, almost 25 years ago, but for a few months, and Tony and the first generation of panelists were appointed to determine claims of cyber squatting, they were working in the dark. They had no law to apply. There had been a handful of cases from U.S. district courts, and there was a case in the U.K., and Tony had mentioned some other cases. The U.S. Congress had passed some legislation in 1995. None of this was adequate to meet the emergency of suppressing cyber squatting. So in the absence of the law, what do skillful lawyer panelists do when all they have is guidance from a code-like set of procedures and rules? Well, they start a process of interpreting the language of the code. They, in other words, they create law, and over time, their interpretations form a jurisprudence. This has been recognized by WIPO overviews. In fact, the 2017 version calls itself a jurisprudential overview. Supposedly, this is not a precedential law, but it is, in the sense, it's law filtered through authoritative decisions. And Tony has been instrumental in this process of creating, or I should say, discovering law. And now, 25 years later, we have a functional jurisprudence. I will now make a controversial second point, although it's built a little bit on what Brian mentioned in his introduction. Because of this, the ICA, the Internet Commerce Association, which is an association of investors and its members, owe a debt of gratitude to the first generation of panelists, because as a result of their definitional work in defining of rights, we have a secondary market of domain names. And it's in my view that only because we have a jurisprudence, and again, thanks to that first generation, thanks to WIPO, we do have a secondary market. And I think that's extraordinary. And so, Tony, thank you so much for such an instructive essay into the UDRP. And I turn it over to Camille.
Thank you.
Thank you, Gerry, so much. So we do have a little bit of time. If there are any questions, I'll turn it over to Zach and Brian.
Sure. Well, what a treat that was, Tony. I mean, we've had well over 70 participants, all who came out to hear you and are overjoyed with the thought-provoking lecture that you provided in honor of Gerald Levine and his scholarship. And Brian and I might be able to come up with a couple questions between ourselves before we end. Brian, do you have any question at the top of your mind?
Well, I thought it would be fun to ask Tony about one of his favorite cases, but I think he's walked us through many examples. It's really hard to obviously we could go into some substantive questions, but I think that's kind of besides the point with the focus of today. I thought, Tony, thank you very much. It was really remarkable to hear a kind of a retracing of some of the history of your Netscape case and David's Walmart, and then the Pline case, and to sort of see that even though if you look back at certain moments in ancient UDRP history, it might have felt perhaps in those moments that things were diverging a little bit, I think, everyone appreciates the value of consistency. But it was really remarkable to sort of, retrace those steps and see how over time a consensus emerged on different topics, and that lands us where we are today. Surely there's, new issues that will evolve. That's part of the aspect of this work that keeps it interesting and keeps everyone on their toes. And I think, with panelists like yourself and others who have joined us today, we're in good and safe hands to navigate those waters, and when the moments are right in cases to find consensus when new issues merit that. So really want to just say thank you, Tony. It was remarkable, and we're grateful for all your work for over the years.
Thank you.
Yes, there's many substantial questions that could be asked about the policy and your remarks on it, but I think I'm going to follow Brian's lead on this and ask you something not substantive in nature. Tony, it's remarkable the different fields you have encountered as a panelist, and you mentioned some of them, from Australian homes, brothels to cursors to fine jewelers, and runs the gamut. So there's many panels here today. Some are newer panels who haven't been around from the very outset of the UDRP. What would be your advice generally to newer panelists in that would be useful to them in how to approach deciding a UDRP case?
Good Lord. Well, for me, the Bible is now the overview, and it's a very good starting point. I suppose the fear is with a new panelist may come out with something. If you rely, sorry, I'm being incoherent. If you wanted to find a case to support anything, any proposition that you wanted to put forward, and if you go far back into the history of the UDRP and the overview, you can find a case to support virtually any argument you want to put forward. I think that concentrate on the most recent cases. And so I can't remember one of the cases earlier this year. Virtually every case cited was dated 2000, 2001, 2002, 2003, all completely out of date. So follow the latest decisions and rely heavily on the overview.
Thank you. Brian, do you have another question, or maybe I can ask another general one based upon some questions in the chat?
Go right ahead.
Okay, so we're going to wrap up shortly, folks, but one of the last questions, Tony, and this is based upon some of the questions in the chat. How do you feel about continuing education and its importance for panelists? Whether it be the annual WIPO seminars and educational series or otherwise.
Well, probably how I should have answered the previous question. I think that they should. I think it's hugely important that they attend the panelist meetings and the workshops. And I don't know, certainly with Nominet, we have the same. We don't have the workshops. We have the panelist meetings, and there's a facility for listening in from overseas. I don't know if it's the same with the WIPO ones, but I think that's where you get an opportunity to talk to people. Everybody has issues over some aspect of the whole procedure and policy, and it's only through conversing either in person or through correspondence that you actually get to an answer. And I felt, certainly at the outset, I felt very lonely. It was quite extraordinary how you're used to being, as a litigator, I was sitting in front of a judge, standing in front of a judge, and suddenly you're switched round to the other side. And I quickly learned why it is that judges always look so bad-tempered. I thought it was they had sort of bilious complaint of some kind, but it wasn't. It was how often the arguments put to them are so stupid. And I found that with a lot of the early cases. It's not so common now, but it still happens now. You still get people citing use of a proxy or privacy service as a basis for a finding of bad faith. And you'd have thought by now, surely that must be out of date.
Thank you. Brian, why don't you go ahead and ask the last question?
Well, just thinking out loud, Tony, you know, I mean, we've all seen that, you know, so far the UDRP stood the test of time. And I remember in my first meeting ever, we were told that apps were going to take over. And so why are we all wasting our time talking about domain names? And of course, there's always something that comes. But just wonder if you have any thoughts on looking into the crystal ball, whether that would you know mean different ways that parties and panelists would navigate you know future forks in the road. How parties can educate panelists may be a good topic, but any kind of crystal ball gazing that you might be able to share with us, I think would be interesting to hear.
One thing I remember was you and I went to New York and we did a workshop in David Bernstein's office in New York. And I think that's where I first met Gerry. I think that if there were more of those sort of things, I think that would be hugely educational. Nominet sent me to New Zealand to talk to would-be New Zealand panelists. And we also, I think I went with WIPO as well to South Africa doing the same thing. And it's all through that we, but looking into the future, I mean, one of the strange things was that after my first two cases, which were the first two cases in the English courts dealing with domain names, suddenly I was being billed as the expert on domain names. So much so that Cambridge University invited me to go up and do a lecture in Cambridge on domain names. And to my horror, I found that the audience was pretty well filled with techie specialists who wanted to know something rather different from domain name disputes. And my knowledge of the system beyond domain names is actually pretty weak. So I don't think I've got the crystal ball ability to be able to express a view on how things are going to go. But if things remain the same at the moment, it seems pretty good. But of course, it's the domain name investors who are, in a sense, the people best able to comment, because I'm only seeing it from one point of view, and it would be helpful. Well, it'd be very, at Nominet this year, for example, at the our annual panelists meeting, we were addressed by a domain name investor, and it was phenomenally educational. I had no idea of the reality of the economics behind investing in domain names. I mean, I think it would be very helpful if panelists were more aware of that. And you know, we have, in ignorance, we have strange views about how profitable it might be, but this chat was alerting us to how unprofitable it can be. Anyway, information is everything, so the more we can learn, the better.
Thank you. Well, listen, this has just been so terrific. Thank you to all the people who participated in the chat. There's so much expertise in this webinar, and really appreciate you attending. Demonstrates just how interested people are in the subject matter. And I'll turn it back to Camila for closing remarks. Thank you. Thank you, Brian. Thank you, Tony. Thank you, Gerry.
There'll be more, but thank you again to everyone for participating. Tony, again, an amazing lecture. We so appreciate you taking the time and doing this for our listeners. Gerry, Brian, thank you again as well for joining us. Yeah, we look forward to future ones. This is a series, so we will host another lecture in the future, and we look forward to hosting everyone then. Thank you again, and take care, everyone.
Thank you.